Armstrong, Judge Stafford, and Judge McGee. My name is Michael Mize, and I am the attorney for the appellant. Though I have been in this room many times in front of the Court of Criminal Appeals, this is my first appearance in the Court of Appeals. I pray that the Honorable Richard Dinkins is looking down upon me. I had the honor of clerking for him briefly when he was first appointed to the court. I stand on the brief that was submitted in this. Would
you like to reserve any rebuttal?
Oh, yes. Thank you, Your Honor. I would. 4 minutes, please.
4 minutes, all right.
I appreciate that, Your Honor. I always forget that.
All right.
I stand on my brief. However, I came to this case very late. I was not involved in this case until after the notice of appeal was filed. I was appointed then by the judge out of Houston County. As I began to work on this case and study it and understand it and visit with my client, I was reminded of 2 particular works from my past. First is the great book by Viktor Frankl, Man's Search for Meaning, in which he quotes Nietzsche in saying, "If you have a why, you can endure anyhow." My second is my new affection for Paul Tillich, and particularly for The Courage to Be, in which Tillich talks about ultimate concern. I bring that up primarily because I hope to stand before you today to convince you that Mr. Baker has a why, and he has an ultimate concern. Mr. Baker is, I believe, very much interested in at least getting the chance to be with his daughter again and to be able to care for her. I know from this morning's cases that your honors are already well prepared and aware of this case. I'm not going to recite the history and the statement of the case and so forth, but I do want to bring out a couple of things. I spent 8 years on the bench in the juvenile court in Dickson County, and on the first docket day of every month, I would read from 37-1-101. I believe in the purpose of the juvenile court, and I believe that we are here to help families. But I believe in this particular case, in this particular instance, the juvenile court failed in its effort, in no effort, to help Mr. Baker, even though he was incarcerated. Mr. Baker, as you can tell, I hope you can tell from a reading of the record, Mr. Baker is passionately interested in and wants to care for Ciara. He, even though has been in prison this whole time, which you know has been even before, he was incarcerated even before Ciara was removed from the mother. And during that whole period of time, I'm kind of going to the third issue. During that whole period of time, he got no help. He received no help whatsoever from the Department of Children's Services. He was throughout, and I know that the state is saying that we waived this issue or that I had failed to clearly bring this issue up, but he received no attorney during the whole dependency and neglect proceedings of this case. He wasn't even aware of it until he received the final permanency plan and the petition to terminate his parental rights. He was appointed no attorney during the DNN, and despite multiple efforts, as you can tell from his testimony, in trying to get some type of response, he received no response. He never got a visit from a caseworker, and as you can see from the record, he sent multiple letters and requests. Even though the record is clear that the department did much for the mother, and even though the mother was in and out of jail, and even though the mother was incarcerated at times during the case, she did get visits from the caseworker, and she did get permanency plans, and she did get opportunities to have assessments and to follow through with those assessments and do all of that. And despite the fact that Mr. Baker didn't receive any of that, he still, on his own, pursued that while he was incarcerated. He's gotten his GED. I'm going to be filing a motion just to supplement the record a little bit because I have certificates to back up what was in the testimony as well. He received his high set. He graduated while he was incarcerated. He got perfect attendance records. He got a certificate for serve safe food. He also attended many hours of victim impact, and he completed a career management as well. Yes, I know that reasonable efforts now has been actually kind of reduced as a part of the grounds in the termination. However, as this court well knows, reasonable efforts is still something that needs to be weighed when it comes to the best interest of the child. In this particular case, we're not talking about just reasonable efforts, we're talking about no efforts whatsoever.
So, Mr. Mize, let me ask you a question then. Are you saying that that alone should completely outweigh all of the other findings that the court made as to as to best interest of the child? Because we have findings on lots of factors. And so you're saying that none of those matter, that trumps all those other findings the court made on best interest?
I'm not saying none of those matter. What I'm saying is it is a weight thing. It's such a hard decision to make. I understand that these factors apply. But the reason that some of these factors apply is because the father really had no opportunity. He had no chance, after being incarcerated, he had no chance to really reestablish a bond with the child. I
why was he incarcerated?
Well, there were two offenses, actually, as you'll look in the record. And I realized, too, that he was incarcerated for rape. He pled nolo contendere.
After the birth of the child, correct?
That's correct. It was 13 months after the birth of the child. The first charge was a result of the mother calling the police for a domestic assault, and it was then that he was charged also with sex offender violation registry because he had moved and he had not registered his move. That was when the mother was pregnant, but before the child was born.
He was already on the sex offender registry at that time and subject to its requirements when that offense took place.
That's correct.
Thank you.
Yes.
So when was he actually incarcerated?
He was incarcerated in 18, I think. I think it was 2018, 17 or 18, if I'm not sure. The child was removed. The child always has been in the custody and care of the mother. It was from the mother that the child was removed because of drug exposure.
Correct.
And so forth.
I'm just trying to ascertain how much time he actually had with the child before he was incarcerated.
He spent about the first year. And in fact, in his testimony, he says there was about a 3-month period in that first year of the child that he was actually primarily caring for the child while the mother was trying to get drug rehabilitation. She was in some type of treatment and trying to get help.
Well, the child was born in August of 2016.
Yes, that's correct. And it was during that, from 16 to 2017, that he did have a relationship with the child. He had visitation on weekends. He also had, like I said, a 3-month period where he did bond with the child. And you'll see in the testimony where
what you're saying is they were separated during this period of time?
Yes, the parents.
Yes.
Yeah, I'm not exactly sure. I think I don't know if they were living together. I don't think they were living together. I think they were separated, but to be honest, Your Honor, I don't know the exact answer to that question.
You said that he testified that he was having weekend visitation. Was that during that time? So
yeah, and I think that was just by agreement. I don't think it was because of a court order. I think, and then there was a period of time when she went to get help and he took care of the child for about 3 months, while the child was, I think, within the first year. As to Quickly, as to the other, so that's kind of the third issue in the brief. But as to the first and the second, as to the wanton disregard is a difficult question because, as I said before, there are two offenses. One that occurred when the mother was pregnant, the other one in which occurred 13 months after the child was born. However, the child was primarily in the custody and care of the mother during that time. How you weigh that, I argue in the brief that there's a difference between wanton and reckless. I do not believe that this rises to wanton disregard, but it's a heavy and difficult question. As to the second issue, which is to the ability and willingness to care for the child, there is no doubt Mr. Baker has a huge willingness. And you can tell from the testimony as well that he wants to care for the child.
But does he have the ability?
He does not at this point. However, he is scheduled to be released in July. He was sentenced to 8 years. He has done great in prison. He has no violations, and he desperately wants to demonstrate the ability. What we're asking for is another chance for him to demonstrate, not to throw the child back into his custody, but that chance for him not to have his parental rights terminated and at least show the court that he is a changed man and he can be a good father.
Do you have any case that supports what you're asking for, that you're asking for this future time, hold off and wait and see?
I don't at this time. No.
Thank you.
I just...
Thank you.
You're welcome.
You've got your rebuttal time.
Thank you.
Hear from the appellate.
Good morning. May it please the court, Mara Cunningham with the Tennessee Attorney General's Office, here on behalf of the Tennessee Department of Children's Services, defending the Houston County Juvenile Court order terminating father's parental rights. We are here for the goal to establish permanency for this now 7-year-old little girl who has not seen or heard from father since she was about 13 months old. This court should affirm the termination of father's parental rights because the record supports that the department proved by clear and convincing evidence that grounds existed to terminate father's parental rights and that termination was in the child's best interest. Before I reach the merits of the actual case, I just wanted to address the waiver issue that father brings up for his lack of counsel at the dependency and neglect proceedings. The case law is clear that where a father is properly represented by counsel in the termination proceedings, that resolves that any potential due process issue. So there is no argument as to the dependency and neglect proceedings because he was properly represented by counsel at the termination proceedings. So moving on to the merits of the actual case, first in regard to grounds for termination, father demonstrated a wanton disregard for the welfare of the child, and he failed to manifest an ability to care for the child. As to wanton disregard, this triggering incarceration is his arrest for the amended charge of rape. He pled no contest in November 28th, 2018, and he was sentenced to 8 years. He was arrested for this charge in September 15, 2017. In re Audrey S. lists a series of conduct that, when viewed either alone or in combination, clearly demonstrate a wanton disregard for the child's welfare, several of which are present here. First, as to criminal behavior, father was arrested twice while he was aware of the child's existence. First, for the arrested of domestic violence for hitting mother with a broom while she was 3 months pregnant with the child, and also arrested for the aggravated rape of his mentally handicapped niece. Second, he violated probation as he failed to report his change of address as per his requirement for the sex offender registry. So he violated the sex offender registry there. And third, he failed to provide adequate support or supervision of the child. First, prior to arrest, he left child with mother. He was the primary caregiver for 3 months, but of 3 of the 10 months that she was remaining before he was arrested, he left with the child with mother, who he knew to be an unfit parent due to her drug abuse. And then he exhibited conduct that led to his arrest for the majority of her life. Again, leaving the child with the unfit parent of mother. As to failure to manifest, father has no current ability to care for the child. While he may be willing to care for the child, the law is clear that it is an either situation. He needs the ability and the willingness, and he does not have a current ability here. He has been incarcerated the entirety of the custodial episode with no plan for housing or employment for when he's released. And also, reintroducing father to the child at this point would pose a substantial risk of the child harm to the child's psychological welfare. There is case law that shows where reintroducing a stranger to the child's life poses a substantial risk of substantial harm to the child's psychological welfare, and as the child has not seen the child, or as the child has not seen or heard from father since she was 13 months old, father is clearly a stranger to her at this time. She has never asked about father, and she considers her foster parents mom and dad. Moving on to best interests. This is looking at the old factors as the petition was filed prior to the factors were updated in April 21 of 2021. This petition was filed on April 1st, just before that. So the old factors are what we are reviewing today. Father's best interest argument relies heavily on this lack of reasonable efforts for factor 2. He relies on In re Kalia S to hold that best interests or reasonable efforts is a requirement to be looked at. However, In re Kalia S is clear that reasonable efforts is not a precondition to termination of rights. In fact, it is just one single factor to be addressed.
And so, what is the obligation of the state here?
So the state had very little opportunity to provide any reasonable efforts as father was arrested the entirety of the case. They had difficulty contacting him. The record is clear that he was served.
They knew where he was, didn't they?
They did know where he was,
Okay.
yes, Your Honor.
So I don't understand the difficulty contacting him.
So they tried to contact him, but it was just difficult due to his incarceration. It is argued that it is not a heavy factor to be considered. If you do determine that it should have been considered, it is heavily outweighed by the remaining factors.
Well, look, before you're getting ahead of me here, what was the obligation, or what is the obligation of the state in this type of situation?
Well, the state seeks to reunify parents with a child. However, here reunification was not a possibility at the time because he was incarcerated the entire time.
I understand that, but again, what is the obligation of the state when you've got this fact situation? You've got an incarcerated parent, you've got a child that's been declared dependent and neglected. So what type of obligation does the state owe to the appellant here?
So you are required to have reasonable efforts. However, there were no services that DCS could have offered due to his circumstances. They did provide the permanent.
What was the proof of that?
I don't believe any was introduced as to that fact.
Okay, so, I mean, obviously there was a caseworker
Yes.
who was in charge of this, had the decision already been made, or when was the decision made that termination was the go?
So the termination petition was filed in April 1st of 2021. Prior to that, father was included in all of the permanency plans with the sole goal of resolving his criminal
Does that mean
charges.
they were sent to him?
He said that he received all court documents. The record is only clear for a fact that that he was sent the final permanency plan, however.
Okay.
So as to the other three, the record is unclear as to that, but it was definitive that he received the final one, and father testified that he received all court orders and other court documents. But as to the final plan, it was definitively sent to him, yes.
Okay. And nobody ever had any contact with him, I'm assuming?
Not until closer to the trial, I believe.
Okay.
Does this fall under any of the exceptions for DCS having to exercise reasonable efforts?
So severe abuse was not found, so they were not relieved of reasonable efforts, as to my knowledge, which is why I believe that they continued to include him in the permanency plan, with his goal of resolving his criminal charges. But because he wasn't involved in her life like 3 years prior to removal, there was nothing that DCS knew to do for services or anything like that. So his criminal charges to be resolved was really the only thing that they were looking for at that time.
Was there any testimony as to why no efforts were made?
DCS said that they attempted to contact him in prison, but it was difficult to maintain contact with the jail.
With all due respect, what does that mean?
Yeah, honestly, Your Honor, I'm not sure. That's just what the transcript said, was that they had a difficult time contacting father while he was incarcerated.
Okay. Does the record indicate what efforts were made? For instance, did they send him a letter?
That is not clear, Your Honor.
Okay.
He did receive mail from them. What that specific mail was not established.
So we know that they could mail stuff to him because they mailed the permanency plan.
Yes, and they did say that he had received mail from them prior to that. It just does not say what that was.
But yet it was difficult to contact him.
Yeah, I'm assuming he meant over the phone. I'm not entirely sure.
All right.
Moving on to the other factors. So if reasonable efforts is determined a two-way against termination, the other factors severely outweigh that one factor. As to factor one, father has demonstrated no lasting change of circumstance. He has remained incarcerated for a violation or for a rape charge while he was previously on the sex offender registry. And so that has not changed. As to factors 3 and 4, there has been no visits or contact and no meaningful relationship between father and the child. Father has not seen or heard from...
How could there have been contact?
So father has not seen or heard from the child since she was 13 months old, 3 years prior to DCS's involvement. So the fact that he had no contact with them, with the child, was even before DCS's involvement with the child.
So we know from the record that he was not involved in the dependent and neglect action.
Correct. He was served all of those documents, however.
He was served those documents, okay.
For the record, yes.
And that's in the record as well?
Yes.
And he never attempted to contact DCS, I take it?
He says he sent them letters. DCS testified that they did not receive any.
Okay, but once the termination petition was filed, that's when the contact started again, I'm assuming?
Yes.
Okay.
So as to a change of caregiver having a negative effect on the child, which is factor 5 of the old best interest factors, this child is in a stable home with her maternal half-brother, who her current foster parents have already adopted her. She has been in the same home since she was removed from mother's custody at the beginning of the case. At the time of trial was over 2 years. Foster parents have testified to loving the child and caring for the child and wanting to adopt the child. So she considers this foster parent's mother and father. So removing her from this stable home would have a negative effect on the child. As to factors 6 and 7, father has shown brutality towards a family member. He was arrested for the aggravated rape of his mentally handicapped niece and has no safe home as he is still incarcerated. As to factor 9, there is no consistent child support. The only support that father has provided was $700 taken out of his COVID stimulus check, which he did not even find out about until after the fact. While father does have a desire to have the ability to raise the child or to be involved in the child's life, any conflicts of interest between parent and child should be resolved in favor of the child. Looking at best interest, you have to determine what's best for the child, and in this case, it would be to terminate father's parental rights. If there are no further questions, to conclude, the state asks this court to affirm the termination of father's parental rights. Thank you.
Thank you.
I'm going to take it backwards. First off, he did not receive all permanency plans. He received the last one. He received the one that was in June of 2023. That was the only permanency plan he ever received. Also, as to child support, he didn't know that he owed child support until he received that last permanency plan.
Does that make a difference?
It does if you're incarcerated and you don't even have the means or ability to go out and investigate and figure out if you're supposed to pay or get a job to be able to pay. He would love to have paid. If you look at his testimony, he even says when he was, before his incarceration, he did consistently contribute to the mother and to the care of the child as well, and was working as well. Respectfully, the opposing counsel says that he was properly represented at the termination of parental rights. I know we're not here to argue. I know that Justice Lee in Carrington was frustrated by the fact that we don't have a remedy for ineffective assistance of counsel when it comes to the termination of parental rights. And I'm not necessarily here today to argue that the counsel that he was appointed was ineffective, but my client was never contacted or discussed. He had no contact with his attorney before the TPR. He was present at the TPR only by Zoom.
Are you telling us stuff that's in the record?
Do what?
Are you sharing information with us that's in the record?
Yes, it is in the record.
Okay, so
it's in the transcripts.
your client said, "I have not had this I've not talked to the client
No,
counsel."
that I don't think he testified to that fact. That's true, Your Honor. As far as the state's argument that contact or reunification with the child would be detrimental at this point, I agree, having the experience that I've had, that would be detrimental if it were to be suddenly. But the juvenile courts all the time reintroduce children to parents they have been estranged from for many years in a very therapeutic setting, in a very gradual way, and I don't believe that in this particular case, I believe in this case that would be appropriate. The obligation of the state is just reasonable efforts. There were no efforts here. I question, I'm not sure, I'll have to go back and look at the record. According to my client, he didn't even receive the pleadings in the DNN, but it's possible. But again, there's testimony there that he said he mailed dozens of letters. And in fact, he specifically testifies as to the caseworker that was first on the case, Miss Ryan, whom I know from the particular district in which she works, that he sent letters to her. He also sent letters, because he did get the address, he sent letters to the department. He even testifies because he knew it was on Cowan Street, which is where the department is.
Did Ms. Ryan testify at the hearing?
She did not.
Did you
It was-
subpoena her?
Do what?
Did you subpoena her?
I was not the counsel at the hearing, which is
Oh,
once
all right.
again an example of the ineffective counsel. When you go through the transcript, I wish I had been the counsel at the hearing, but I was not. And the argument that in the best factors that he had not visited the child or seen or heard from the child throughout the whole case is not his fault. He attempted to do so, and Your Honor is correct. They knew where he was. I go visit clients all the time. In fact, sometimes it's best for me when they are incarcerated because I know exactly where they are and I know how I can help them. So they did that for the mother. They did not do that for the father.
So are you saying that DCS should have taken the child to the prison to see him?
No, not right away, but they could have started out with letters. We do this all the time, in which the father would be allowed, and in fact, they screen those letters. The department does that all the time. The father could write letters to his child. She could then write back. He could send pictures. He did send pictures, but I don't know where they went or what happened to them. And then eventually, we could go to some phone calls, and then eventually now, even video, Zoom, that type of thing. I understand. I never want to take a child into a prison for a visit either. But there are ways to be able to generate that kind of contact throughout the case so that when he is released, it's not all of a sudden a brand new introduction to this, this father she hasn't seen. There are ways that DCS could have done this, and they did nothing.
Thank you. You've used your time. Thank you, counsel. We will take this matter under advisement and will attempt to get you an opinion at the earliest possible time. We will stand in recess to the call of the docket this afternoon.